New Jersey, when dealing with distribution of assets and liabilities, defines itself and its process as an equitable distribution state. Equitable doesn't mean community, marital, or equal distribution. Equitable means that assets and liabilities may not be divided 50-50 down the middle. There are a lot of factors that a court, litigants, and attorneys have to consider when looking at how to distribute both assets and liabilities. Things like, are assets inherited? Were they commingled with premarital assets and post-divorce assets, where there has been a gift to the marriage from either party's family or a gift to an individual from either party's family? These are the type of things that lawyers, litigants, and the court has to consider when figuring out how assets are divided. A lot of times people have the initial assumption that everything is going to be divided 50-50 and that there's no other opportunity for what's known as an inequitable split of assets or liabilities. However, it's important for an attorney to understand, where did the assets come from? Where were the debts accumulated? What time frame did these occur in? Were they utilized for the marital enterprise? Were they a dissipation of the enterprise's assets such that one spouse should be afforded a credit for the other spouse's unreasonable spending? There is a lot of nuance in these complex distribution cases, and it's important that a litigant is as transparent with an attorney as possible, providing as much documentation, history, and information as possible so that the attorney can appropriately review and determine whether there are any real legal sound bases for making a claim that assets should be divided in a manner other than 50-50. It's important that you come to a strategic planning session or go to court armed with as much information as possible so that you, your lawyer, and the court can reasonably understand what is an appropriate distribution.